Hello friends, today's topic is from the Indian polity M. Laxmikant, citizenship, meaning and the significance. Like any other modern state, India has two kinds of the people, citizens and the alliance. Citizens are the full member of the Indian state and the alliance to it. They enjoy all the civil and the political rights. Aliens, on the other hand, are the citizens of some other state and hence do not enjoy all the civil and the political rights. They are of the two categories, friendly aliens and or the enemy aliens. Friendly aliens are the subjects to those countries that have cordial relations with the India. Enemy alliance, on the other hand, are the subjects of that country that is at war with India. They enjoy lesser rights than the friendly alliance. That is to say, they do not enjoy protection against the arrest and the detention. Article number 22. If you like to this video, then please like, share and subscribe to watch more videos like this. The Constitution confers the following rights and privileges on the citizens of the India and denies the same to the alliance. Number 1. Right against the discrimination on the ground of the religion, race, caste, sex or the place of the birth. Article number 15. Right to the equality of the opportunity into the matter of the public employment. Article number 16. The right to the freedom of the speech and expression, assembly, association, movement, residence and the profession. Article number 19. Cultural and educational right. Article number 29 and 30. Right to vote in the elections to the Lok Sabha and the State Legislative Assembly. Number 6. Right to the contest for the membership of the Parliament and the State Legislature. Number 7. Eligibility to the hold certain public offices, that is President of the India, Vice President of the India, Judges of the Supreme Court and the High Court, Governor of the State, Attorney General of the India and Advocate General of the State. Along with the above rights, the citizens also owe the certain duties toward the Indian state, as for example paying tax, respecting the national flag, national anthem, defending the country and so on. In India, both a citizen by the birth as well as the naturalized citizen are the eligible for the office of the president, while in USA only citizen by the birth, not a naturalized citizen, is eligible for the office of the president. Constitutional provisions. The Constitution with the citizenship from the article number 5 to 11 under the part 2. However, it contains neither any permanent nor any elaborate provisions in this regard. It only identifies the person who become the citizens of the India at its commencement, that is to say, on the January 26, 1950. It does not deal with the problem acquisitions or the loss of the citizenship subsequent to its commencement. It empowers the Parliament to enact a law to provide for such matters and any other matter relating to the citizenship. Accordingly, the Parliament has enacted the Citizenship Act 1955, which has been amended from the time to time. According to the Constitution, the following four categories of the persons became the citizens of the India at its commencement, that is to say, on the January 26, 1950. Number 1. A person who had his domicile in the India and also fulfilled any one of the three conditions, viz. If he was born in India, or if he either of his parents was born in India, or if he has been ordinarily resident in India for the 5 years immediately before the commencement of the Constitution, becomes a citizen of India. Number 2. A person who migrated to the India from Pakistan become an Indian citizen if he or either of his parents or any of his grandparents was born in undivided India and also fulfill any one of the two conditions, that is to say, in the case of the migrated India before July 1948, he had been ordinary residents in India since the date of his migration, or in case of he migrated to the India on or after the July 1948, he had been registered as a citizen of the India. But a person could be so registered only if he had been the resident in India for the 6 months preceding the date of his application for the registration. Number 3. A person who migrated to Pakistan from India after March 1, 1947, but later returned to the India for the resettlement could become an Indian citizen. For this, he had to be the resident in India for the 6 months preceding the date of his application for the registration. Number 4. A person who or any of whose parents or grandparents was born in the undivided India, but who is ordinarily residing outside India shall become an Indian citizen if he has been registered as a citizen of India by the diplomatic or the consular representative of the India of his residence, whether before or after the commencement of the Constitution. Thus, its provision cover the overseas Indians who may want to acquire Indian citizenship. To sum up, these provisions deal with the citizenship of A. Persons domiciled in India. B. Persons migrated from Pakistan. Number C. Persons migrated to Pakistan but later returned. And D. Persons of the Indian origin residing outside India. The other constitutional provisions with respect to the citizenship are as follows. Number 1. No person shall be the citizen of India or be deemed to be the citizen of India if he has voluntarily acquired the citizen of any foreign state. Number 2. Every person who is or is deemed to be the citizen of India shall be the continue to be the such citizen subject to the provisions of any law made by the Parliament. Number 3. Parliament shall have the power to make any provision with respect to the acquisition and the termination of the citizenship and all other matters relating to the citizenship. Citizenship Act 1955. The Citizenship Act 1955 provides for the acquisition and loss of citizenship after the commencement of the Constitution. Originally, the Citizenship Act 1955 also provided for the Commonwealth citizenship, but this provision was repealed by the Citizenship Amendment Act 2003. Acquisition of the citizenship. The Citizenship Act 1955 prescribes 5 ways of acquiring citizenship by birth, descendant, registration, naturalization, and incorporation of the territory. Number 1. By the birth. A person born in India on or after January 26, 1950, but before the July 1, 1987, is a citizen of the India by the birth, irrespective of the nationality of his parents. A person born in India on or after the July 1, 1987 is considered as a citizenship of India only if either of his parents is a citizen of India at the time of his birth. Further, those born in India on or after the December 3, 2004 are considered citizens of the India only if both of their parents are citizens of the India or one of whose parents is a citizen of India and other is not an illegal migrant at the time of their birth. The children of the foreign diplomats posted in India and enemy allies cannot acquire Indian citizenship by the birth. Number 2. By the descent. A person born outside of the India on or after the July 26, 1950, but before the December 10, 1992 is a citizenship or citizen of the India by the descent if his father was citizen of the India at the time of his birth. A person born outside of the India on or after December 10, 1992 is considered as a citizen of the India if either of his parents is a citizen of the India at the time of his birth. December 3, 2004 onwards, a person born outside of India shall not be the citizen of India by the descent unless his birth is registered at an Indian consulate within the 1 year of the date of the birth, or with the permission of the central government after the expiry of the said period. An application for the registration of a birth of a minor child to an Indian consulate shall be accompanied by the undertaking in the writing from the parents of the such minor child that he or she should not be hold the passport of the another country. Further, a minor who is citizen of the India by virtue of the descent and is also citizen of any other country shall cease to be the citizen of the India if he does not renounce the citizenship or the nationality of the another country within the 6 months of his attaining full age. Number 3. By registration. The central government may on an application register as a citizen of the India any person not being an illegal migrant if he belongs to any of the following category, namely: A person of the Indian origin who is ordinarily resident in India for the 7 years before making an application for the registration. B. A person of Indian origin who is ordinarily resident in any country or the place outside the undivided India. Number C. A person who is married to the citizen of the India and is ordinarily resident in India for the 7 years before making an application for the registration. Number D. minor children of the person who are citizens of the India. Number E, a person of a full age and a capacity to whose parents are registered as a citizens of the India. Number F, a person of the full age and the capacity who or either of his parents was earlier citizen of the independent India and is ordinarily resident in India for the 12 months immediately before making an application for the registration. Number G, a person of a full age and capacity who has been registered as an overseas citizen of the India cardholder for the 5 years and who is ordinarily resident in India for the 12 months before making an application for the registration. A person shall be deemed to be the Indian origin if he or either of his parents was born in undivided India or in such other territory which become a part of India after the August 15, 1947. All of the above categories of the person must be taking an oath of the alliance before they are registered as a citizen of the India. Number 4. By neutralization, the central government may on an application grant a certificate of the neutralization by any person not being an illegal migrant if he possesses the following qualification. A, that he is not a subject or the citizen of any country where citizens of the India are prevented from becoming subjects or citizens of that country by the neutralization. Number B, that he is a citizen of any country, he undertakes to renounce the citizenship of that country in the event of his application for the Indian citizenship being accepted. Number C, that he has either resided in India or been in service for the government of India or partly that one and partly the other throughout the period of the 12 months immediately preceding the date of the application. Number D, that during the 14 years immediately preceding the said period of the 12 months he has either resided in India or been in the service of the government of in India or partly the one and partly the other for the periods amounting in the aggregate to term not less than 11 years. Number E, he is of the good character. Number F, that he has an adequate knowledge of the language specified into the 8th schedule of the Constitution. And number G, that in the event of a certificate of the neutralization being granted to him, he intended to reside in India or to enter into the continue in service under an government in India or under an international organization of which India is a member or under a society, company or body of a persons established in India. However, the government of the India may waive all or any of the above conditions for the neutralization in the case of the person who is rendered distinguished service to the service, philosophy, art, literature, world, peace, or the human progress. Every neutralized citizen must be taken oath to the alliance to the Constitution of the India. Number 5. By incorporation of the territory. If any foreign territory become a part of the India, the government of the India specifies the person who among the people of the territory shall be the citizens of the India. Such persons become the citizens of the India from the notified date. For example, when Pondicherry becomes a part of the India, the government of the India issues the Citizenship Pondicherry Order 1962 under the Citizenship Act 1955. Number 6. Special provisions as a citizenship of the person covered by the Assam Accord. The Citizenship Amendment Act 1985 added the following special provisions as to the citizenship of the persons covered by the Assam Accord, which related to the foreign issue. A. All persons of the India origin who came to the Assam before the January 1, 1966 from the Bangladesh and who have been the ordinary resident in Assam since the date of their entry into the Assam shall be deemed to be the citizens of the India as from the January 1, 1966. Every person of the Indian origin who came to the Assam on or after the January 1, 1966 but before the March 25, 1971 from the Bangladesh and who has been ordinary resident in Assam since the date of his entry into the Assam and who has been detected to be of origin shall register himself. Such a registered person shall be deemed to be a citizen of the India for all purposes as from the date of the expiry of the period of the 10 years from the date of the detection as of origin. But In the intervening periods of the 10 years, he shall have the same rights and the obligation as a citizen of the India, excepting the right to the vote. Loss of citizenship. The Citizenship Act 1955 prescribes three ways of the losing citizenship, whether the acquired under the act or the prior to it under the Constitution, vice the renunciation, termination, and the deprivation. Number one, by renunciation. Any citizen of India of the full age and the capacity can make and the declaration renouncing his Indian citizenship under upon the registration of that declaration, that person ceases to be the citizen of India. However, if such a declaration is made during a war in which India is engaged, its registration shall be withheld by a central government. Further, when person renounces citizenship, every minor child of that person also loses Indian citizenship. However, when such a child attains the age of the 18, he may resume the Indian citizenship. Number two, by termination. When an Indian citizen voluntarily, consciously, knowingly, and without duress, undue influence, or the compulsion acquires the citizenship of another country, his Indian citizenship automatically terminates. These provisions, however, does not apply during a war in which India is engaged. Number three, by deprivation. It is the compulsory termination of the Indian citizenship by the central government if A. The citizen has obtained the citizenship by the fraud. B. The citizen has shown disloyalty to the Constitution of the India. Number C. The citizen has unlawfully traded or communicated with the enemy during a war. Number D. A citizen has within the 5 years after the registration or neutralization been imprisoned in any country for the 2 years. And in number E, the citizen has been ordinarily resident out of the India for the 7 years continuously. Single citizenship. Though the Indian Constitution is patterned and envisages a dual polity, center and the states, it provides for the only a single citizenship, that is the Indian citizenship. The citizens in India owe an alliance only to the unions. This is no separate state citizenship. The other federal states like USA and Switzerland, on the other hand, adopted the system of the double citizenship. In USA, each person is not only a citizen of the USA but also of the particular state to which he belongs. Thus, he owes the alliance to the both and enjoys dual status of the rights on one set conferred by the national government and another by the state government. This system creates the problem of the discrimination. That is, a state may discriminate in the favor of its citizens in the matters like right to vote, right to the hold public offices, right to the practice professions, and so on. This problem is avoided in the system of the single citizenship prevalent in India. In India, all citizens, irrespective of the state in which they are born or reside, enjoy the same political and the civil rights of the citizenship all over country, and no discrimination is made between them. However, this general rule of the absence of the discrimination is subject to the some exception. Vice number one, Parliament under the Article 16 can prescribe residence within the state or the union territory as a condition for the certain employments or the appointments in the state or the union territory or the local authority or the other authority within the state or the union territory. According to the Parliament enacted the Public Employment Requirement as a Residence Act 1957, thereby authorized the government of the India to prescribe the residential qualification only for the appointment to the non-gazetted posts in Andhra Pradesh, Himachal Pradesh, Manipur, and Tripura. As this act expired into the 1974, there is no such provisions for any state except Andhra Pradesh and the Telangana. Number two, the Constitution under the Article 15 prohibits the discrimination against any citizen on the ground of the religion, race, caste, sex, or the place of the birth, and not on the ground of the residence. This means that the state can provide the special benefits or give preference to its residents in the matters that do not come within the pure view of the rights given by the Constitution of India and citizens. For example, a state may offer concession in fees to the education to its residents. Number three, the freedom of the movement and the residence under Article number 19 is subjected to the protection of the interests of the any Indian tribes. In other words, the right to the outsiders to enter, reside, and settle in the tribal areas is restricted. Of course, this is done to the protect the distinctive culture, language, customs, and the manners of the Sabine tribes, and to the safeguard their traditional vocation and the property against the exploitation. Number 14, the 2019, the legislature of the erstwhile state of the Jammu and Kashmir was empowered to a. Define the persons who are the permanent resident of the state, and B. Confer any special rights and the privilege on the such permanent residents as the respects. Number 1. Employment under the state government. Number 2. Acquisition of the immovable property in the state. Number 3. Settlements in the state. And number 4. Right to the scholarship and such other forms of the aid provided by the government. The above provision was based on the article number 13.5a of the Constitution of the India. This article was inserted in the Constitution by the constitutional application of to the Jammu and Kashmir Order 1954. This order was issued by the President under the Article 370 of the Constitution, which has provided a special status to the erstwhile state of the Jammu and Kashmir. In the 2019, this special status was abolished by the new presidential order known as the Constitution Application to the Jammu Kashmir Order 2019. This order superseded the earlier 1954 order. The Constitution of India, like that of the Canada, has introduced the system of the single citizenship and provided uniform rights, except in the few cases for the people of the India to promote the feeling of the fraternity and unity among them and to be an integrated Indian nation. Despite this, India has been witnessing the communal riots, class conflict, caste wars, linguistic clashes, and the ethnic dispute. Thus, the cherished goal of the founding fathers and of the constitution maker to build and a united and integrated Indian nation has not fully realized. Overseas citizenship of the India. In September 2000, the government of the India Ministry of the External Affairs had set up a high-level committee on the Indian diaspora under the chairmanship of the N.M. Singhvi. That the mandate of the committee was to make the comprehensive study of the global Indian diaspora and to recommend the measures for the constructive relationship with them. The committee submitted its report in the January 2002. It recommended the amendment of the Citizenship Act 1955 to provide the grant of the dual citizenship of the persons of the Indian origin. The Indian origin belonging to specific countries. According to the Citizenship Amendment Act 2003, made provision for the acquisition of the overseas citizenship of the India (OCI) by the POIs of the 16 specified countries other than the Pakistan and the Bangladesh. It also omitted all the provisions recognizing or the relating to the Commonwealth citizenship from the Principal Act. Later, the Citizenship Amendment Act 2005 expanded the scope of the grant of the OCI for the POI of all the countries except the Pakistan and the Bangladesh as long as their home countries on dual citizenship under their local laws. It must be noted here that the OCI is not actually a dual citizenship as the Indian Constitution forbids dual citizenship or the dual nationality. Article number 9. Again, the Citizenship Amendment Act 2015 has modified the provision pertaining to the OCI in the Principal Act. It has introduced a new scheme called the Overseas Citizens of the India Card Holder by the merging the POI card scheme and the OCI card scheme. The POI card scheme was introduced on the August 19, 2002. Thereafter, the OCI scheme was introduced the December 2, 2005. Both the schemes were running in the parallel, even though the OCI card scheme has become more popular. This was causing the unnecessary confusion in the minds of the applicant, keeping in the view some problems being faced by the applicant, and to provide the enhanced facility to them. The government of the India decided to formulate one single scheme after the merging the PIO and the OCI schemes, containing the positive attributes of the both, hence the achieving its objective. The Citizenship Amendment Act 2015 was enacted. The POI scheme was resigned January 9, 2015. It was also notified that all existing PIO cardholders shall be deemed to be the OCI cardholder from the January 9, 2015. The Citizenship Amendment Act 2015 replaced the nomenclature of the Overseas Citizenship India, that the overseas citizens of the India cardholder made the following provisions in the principle. Number one, registration of the overseas citizen of the Indian cardholder. Number one, the central government may, on an application made it in this behalf, register as an overseas citizen of the India cardholder. A, any person of the full age and capacity. One, who is a citizen of the another country but was a citizen of the India time of or any time after the commencement of the constitution. Number two, who is a citizen of the another country but was eligible to become citizen of the India at the time of the commencement of the constitution. Number three, who is citizen of the another country but belong to the territory, became a part of India after the 15th August 1947, or who is the child or the grandchild of the great grandchild of the such an, or B, a person who is the minor child of a person mentioned in the clause A, or number C, a person who is a minor child whose both parents are the citizen of the India, or the one of the parents is a citizen of the India, or the spouse of the origin of the citizen of the India, of the origin of the overseas citizen of the Indian cardholder, and whose marriage has been registered and substituted for the continuous period of not less than the 2 years immediately preceding the presentation of the application. No person who or the either whose parents or the grandparents or the great grandparents is or the had been the citizen of the Pakistan, Bangladesh, or the such other country such as central government may specify shall be the eligible for the registration as an overseas citizen of the India cardholder. Number two, the central government may specify the date from which the existing persons of the Indian origin cardholder shall be deemed to be the overseas citizen of the Indian cardholder. Number three, notwithstanding the anything contained in the point one, that central government may, if it is satisfied the special circumstances exist, after recording the circumstances in writing, register a person as the overseas citizen of the India cardholder. Number two, conferment of the right on the overseas citizen of the India cardholder. Number one, an overseas citizen of the India cardholder shall be entitled to the such rights as the central government may specify in this behalf. Number two, an overseas citizenship of the Indian cardholder shall not be entitled to following right which is conferred on the citizens of the India. A, he shall not be entitled to the right of the equality in opportunity in the matters of the public employment. Number B, he shall not be eligible for the election of as a president. He shall not be eligible for the election of the vice president. He shall not be eligible for the appointment as a judge of the Supreme Court. He shall not be eligible for the appointment as a judge of the High Court. He shall not be entitled for the register as a voter. He shall not be eligible for the being the member of the House of the People or of the Council of the State. He shall not be eligible for the being the member of the state of the Legislative Assembly or the State Legislative Council. He shall not be eligible for the appointment to the public services and post into the connection with the affairs of the unions or of any state except for the appointment in which such services and the post as the central government may specify. Number three, renunciation of the overseas citizen of the India card. Number one, if any overseas citizen of the India cardholder makes in the prescribed manner a declaration renouncing the card registration him as an overseas citizen of the India cardholder, the declaration shall be registered by the central government, and upon such registration, the person shall cease to be an overseas citizen of the Indian cardholder. where a person ceases to be an overseas citizen of the India card holder, the spouse of the origin of the that person who has obtained the overseas citizen of the India card, and every minor child of that person's registered as a original overseas citizen of the India card holder sent thereupon cease to be the overseas citizen of the India card holder. Number 4. Cancellation of the registration of as an overseas citizen of the India card holder. The central government may cancel the registration of the person as an overseas citizenship of the Indian card holder if it is satisfied that the registration as an overseas citizen of the India card holder was obtained by means of the fraud, false representation, or the concealment of the any material fact. B. The overseas citizen of the India card holder has showed the disaffection toward the Constitution of India, or number C. The overseas citizen of the India card holder has, during any war in which the India may be engaged, unlawfully traded and communicated with an enemy, or D. The overseas citizenship of the India card holder has, within the 5 years after the registration, been the sentenced to the imprisonment for a term of the not less than 2 years, or E. It is necessary so to do in the rest of the sovereignty and the integrity of the India, the security of the India, friendly relations of the India with any foreign country, or in the interest of the general public. F. The marriage of the overseas citizen of the India card holder has been dissolved by the competent court of the law or the otherwise, or 2. Has been the dissolved, but during the substance such a marriage has been the solemn marriage with any other person. Comparing NRI, PIU, and the OCI card holder. Elements of the comparison: who, non-residents of the NRI, and the Indian citizen who is ordinarily residents outside the India and holds the Indian passport is the NRI. Person of the Indian origin: a person who or whose any of the ancestor was Indian national and who is presently holding another country's citizenship nationality, he or she holding the foreign passport. The overseas citizen of the India card holder under the citizenship of the 1950 who is eligible. Following categories of the foreign nations are the eligible for the registration of the overseas citizens of the card holder India. Number 1. Who is citizen of the India at the time of the at any time after the commencement of the constitution of the 26 April 1950, who was eligible to become citizen of the India on the 26th 1 1950, who was belonged to the territory become the part of the India after the 15/8 1947, who is the child or the grandchild or the great grandchild of the such citizen, who is the minor child of the such person mentioned above, who is the minor child and whose both parents were citizen of the India or one of the parents is citizen of the India, spouse of the foreign origin of the citizen of the India or the spouse of the foreign origin of the overseas citizen of the Indian card holder registered under the Citizenship Act 1950 whose marriage has been registered and substituted for the continuous period presentation of the application. How to get OCI card? Eligible person to apply online. Number 4. Where to apply? In such time, the online payment facility is introduced. The following instructions shall be the followed. Number 1. The print out of the online application form completed with all the respect along with the enclosure demand draft and the photograph in duplicate should be submitted to the Indian Mission Post having the jurisdiction over the country of which the applicant is a citizen, or if he or she is not living in the country of his or his citizenship, to the Indian Mission Post having the jurisdiction over the country of which the applicant is the ordinary resident. Number 2. If the application is residing in India, the print out of the online application form completed in the all respect along with the enclosure demand draft and the photograph in the duplicate should be submitted to the foreign regional registration office according to the jurisdiction control fees. OCI card A. The case of the application submitted in Indian Mission Post abroad US 275 or equivalent in the local currency. B. In the case of the application submitted in India rupees 15,000. Which nations are ineligible? No person who or either of whose parents or the grandparents or the great grandparents or is had been the citizen of the Pakistan, Bangladesh or such countries. As a central government may specify shall be eligible for the registration as the overseas citizen of the Indian cardholder. What benefits one entitled NRI or the benefit is available to the Indian citizens to be the notified issued by the government of the India time to time. PIO, no specific benefit. OCI, number one, multiple entry, lifelong visa for the visiting India for any purpose. However, OCI cardholder will require a special permission to undertake the research work in India for the which they may submit the application to the Indian Mission Post FRRO concern. Number two, exception from the registration with the foreign regional registration officer is FRRO or the foreign registration officer FRO for any length of the stay in India. Number three, parity with the non-resident Indian is respect of the all facility available to them to economic, financial, and education fields, except into the methods of related acquisition, agricultural, or the plantation properties. Number four, the registered overseas citizen of the Indian cardholder shall be treated at par with a non-resident Indian in the matter of the inter-country adoption Indian children. Number five, the registered overseas citizen of the India cardholder shall be treated as a part of the resident Indian nations in the matter of the tariffs in the airfares in the domestic sectors of the India. Registered overseas citizen of the India cardholder shall be charged the same entry fee and domestic Indian visitor to visit national parks and the wildlife sanctuaries in India. Number 7. Parity of the non-resident India NRA is respect to the entry fees to the charge for the visiting the national monument, historical sites and the museum in. Number B. The pursuing the following professions in India pursuance of the provisions contained the relevant acts, namely the doctor, dentist, nurse, and the pharmacy, advocate, architect, chartered accountant, to appearance for the India private medical test or the such tests to the make them eligible for admission of the pronouncement of the provision of the content relevant. The state government should be the use the OCI cardholder register booklets of the OCI cardholder or treated as their identification for any services rendered to them in case of the proof of the residence of the required overseas citizen of the India cardholder may give an affidavit stating that a particular specific address may be treated as their place of the residence in India. Does he or she require visa for visiting NIRI? No. PIO? Yes. And OCI cardholder can visit India without visa for lifelong. Number 9. If he or she require register for the local police, NRI? No. PIO? Oh yes. If the period of the stay is for the more than 180 days, OCI cardholder? No. Number 10. What activity can be undertaken in India? NRI? All activities. PIO? Activities as per the type of the visa obtained. And OCI cardholder, all activities except the research work for the which the special permission is required from the Indian Mission Post or the FRRO concerned. Number 11. How he can or one acquire Indian citizenship? NRI? He or she is an Indian citizen. PIO? As per Citizenship Act 1950, he or she has been the ordinary resident of the India for a period of the 7 years before making application for the registration. OCI card? As per Citizenship Act 1950, a person registered as the OCI cardholder for the 5 years and who is ordinary resident in India for the 12 months before the making application for the registration is eligible for the grant of the Indian citizenship. Articles related to the citizenship as granted. Article number 5, citizen at the commencement of the constitution. Number 6, rights of the citizen of the certain person who has migrated to the India from the Pakistan. Number 7, rights of the citizenship of the certain migrant to the Pakistan. Number 8, right of the citizen of the certain persons of the Indian origin residing outside India. Number 9, persons voluntarily acquire citizenship of the foreign state not to be the citizen. Number 10, continuance of the right of the citizenship. Number 11, parliament to regulate the right of the citizenship by law. If you like this video, then please like, share and subscribe. Thank you very much.